This video is available in additional languages. Please see the video description for links to these videos.
यह वीडियो अतिरिक्त भाषाओं में उपलब्ध है। कृपया इन वीडियो के लिंक के लिए वीडियो विवरण देखें।
এই ভিডিওটি অতিরিক্ত ভাষায় উপলব্ধ। দয়া করে এই ভিডিওগুলির লিংকের জন্য ভিডিও বিবরণ দেখুন।
On August 11, 2023, the United States Securities and Exchange Commission announced charges against ONPASSIVE LLC and its CEO Ashraf Mufarehs. His wife was also named as a relief defendant in the case. The SEC's complaint alleges that the company in Mufarehs fraudulently raised over $108 million from investors in a multi-level marketing (MLM) arrangement. Per the SEC's complaint, the ONPASSIVE program is a pyramid scheme. The SEC alleges ONPASSIVE and Mufarehs made material misrepresentations about the timing of the commercial product launch, the magnitude of anticipated profits, and the legality of the defendants' operations. ONPASSIVE and Mufarehs also allegedly created websites and posted positive reviews of the defendants to counter negative reviews on existing sites that review multi-level marketing programs. The complaint seeks injunctive relief, disgorgement of ill-gotten gains plus prejudgment interest thereon on a joint and several basis, civil penalties, and an officer and director bar against Mufarehs. The SEC's complaint names Mufarehs' spouse, Asmahan Mufarehs, as a relief defendant. On November 6, 2023, the SEC filed an amended complaint with the court. This amended complaint provides some clarification of the charges, corrects some information contained in the initial complaint, and further explains the limited amount of evidence revealed by the SEC thus far. The following is the amended complaint as filed with the court. It is presented in full, save for some legal references which most viewers of this video would find unnecessary and which would make comprehension more difficult. Filed in the United States District Court, Middle District of Florida, Orlando Division. Amended complaint for permanent injunctive and other relief and demand for a jury trial. Plaintiff Securities and Exchange Commission, SEC or Commission, for its amended complaint against Ashraf Mufarehs, ONPASSIVE LLC, ONPASSIVE or the company, collectively defendants, and relief defendant Asmahan Mufarehs alleges as follows. Summary. This enforcement action arises out of defendants' fraudulent and unregistered offering of securities, in connection with which, among other things, defendants engaged in an illegal pyramid scheme and made materially false and misleading statements to investors in the United States and around the world. Beginning in July 2018 to the present, the relevant period, Mufarehs in his individual capacity and later through ONPASSIVE, an illicit multi-level marketing (MLM) company operating as a pyramid scheme, claimed to be developing a suite of computer applications using artificial intelligence (AI) that would seamlessly interface with one another in an ecosystem similar to applications offered by established, well-known multinational technology companies. Ostensibly to finance the development of the applications and the creation of the ecosystem, from inception through June 22, 2022, Mufarehs and ONPASSIVE pitched potential investors on the opportunity to buy for $97 a position in the pyramid structure, locking in their positions before any launch, as defined below, of the purported product and before others began buying into the scheme in the future. Investors taking advantage of this early bird promotion called founders were assured a higher placement in the pyramid, and higher returns, than later investors waiting to buy into the scheme by making a product purchase and commencing payment of a monthly subscription after product launch. In addition to this early bird founders promotion, defendants represented to potential investors that once product launch occurred, investors and others would eventually be able to make a one-time initial payment to purchase a purported product package and then also pay a monthly subscription fee to use the purported applications. Investors making these payments would, in the case of founders, retain placement in, or, in the case of new investors, obtain placement in, a pyramid structure. Moreover, investors would be eligible to receive as a commission a portion of monthly subscription fees paid by those placed after them in the pyramid structure. As the name ONPASSIVE implies, Mufarehs and ONPASSIVE promoted the scheme as a passive income opportunity by emphasizing that investors did not have to do anything, other than make a one-time purchase of product and pay monthly subscription fees and, in the case of founders, the $97 fee, to receive commissions. Defendants represented that they would engage in a marketing campaign once they effected product launch to recruit other participants and direct the traffic to websites ONPASSIVE created for each founder, and participants joining post-launch, using an automated process. Mufarehs and ONPASSIVE also incentivized participants to recruit as many other participants as possible, claiming a participant's recruits would be placed under the participant and be sources of commissions paid to the participant. Further, Mufarehs and ONPASSIVE incentivized participants to purchase multiple $97 positions in the pyramid to maximize the number of passive income streams. There was no reason an individual would purchase multiple positions other than to increase the individual's potential for income. The offer and sale of the opportunity to participate in the ONPASSIVE pyramid scheme involves investments of money in a common enterprise with an expectation of profits to come from the efforts of others. As such, the ONPASSIVE opportunity is an investment contract and, therefore, a security. The offering and sale of the ONPASSIVE investment contract have never been registered with the SEC and no exemption from registration applies. In furtherance of their fraudulent pyramid scheme, Mufarehs and ONPASSIVE knowingly and recklessly made repeated materially false and misleading statements and omissions concerning, among other things, the timing of product launch, which would trigger commission payments, the potential income to be earned, and the soundness and legality of their operations. In furtherance of their fraudulent pyramid scheme, Mufarehs and ONPASSIVE, to counter negative reviews of them on existing MLM review websites, also furtively created counterfeit websites on which ONPASSIVE personnel, at Mufarehs' direction, then posted internally generated positive reviews of Mufarehs and ONPASSIVE, falsely passing them off as objective, third-party reviews. Effective June 22, 2022, ONPASSIVE ceased accepting any more founder registrations. As of March 2023, ONPASSIVE had received over $108 million from over 800,000 investors located in the United States and abroad who purchased over 1.12 million founders' positions, paying $97 for each position in the pyramid scheme in advance of the supposed product launch. Having chiefly focused on recruiting investors rather than the development of the purported AI applications, Mufarehs and ONPASSIVE continuously delayed any launch of the purported AI applications while claiming that they were being developed or were further along in development than was actually the case. As of June 30, 2023, ONPASSIVE had not yet launched any product for a fee or paid any commissions to investors. Rather than commit investor proceeds principally to develop and commercialize the purported software applications, Mufarehs has used investor funds to further the pyramid scheme and for his and his spouse's personal use. Specifically, Mufarehs transferred investors' funds to his wife, relief defendant Asmahan Mufarehs, including transfers into bank account or accounts held jointly by the Mufarehs or held in Asmahan Mufarehs' name only, or over which Asmahan Mufarehs exercised authority. In addition, the Mufarehs converted a considerable portion of investor funds into crypto assets under their exclusive personal control. The Mufarehs then used funds from these accounts for personal expenses, including online retail purchases, upscale dining, TV subscriptions, groceries, salon and spa visits, and the purchase of stocks. Asmahan Mufarehs does not have a legitimate claim to the funds transferred from ONPASSIVE or Ashraf Mufarehs. Summary of violations. By their conduct as alleged in this amended complaint, defendants each violated the registration provisions of Sections 5A and 5C of the Securities Act of 1933, Securities Act, and the anti-fraud provisions of Section 17A of the Securities Act and Section L0B of the Securities Exchange Act of 1934, Exchange Act, and Rule L0B5 thereunder. Moreover, by his conduct as alleged in this amended complaint, Defendant Mufarehs had the power to control the general affairs of ONPASSIVE at the time ONPASSIVE violated the securities laws as alleged herein, and Mufarehs directly or indirectly possessed the power to direct or cause the direction of the management and policies of ONPASSIVE, and, therefore, Mufarehs is liable jointly and severally with and to the same extent as ONPASSIVE for its violation of Section L0B of the Exchange Act Rule L0B5 thereunder, pursuant to Exchange Act Section 20A. Unless defendants are restrained and enjoined, they are reasonably likely to continue to engage in the acts, practices, transactions, and courses of business set forth in this amended complaint or in acts, practices, transactions, and courses of business of similar types and objects. Defendants. Ashraf Mufarehs, age 50, is a resident of Orlando, Florida. He is the co-founder and co-owner with his spouse, Asmahan Mufarehs, of ONPASSIVE and, throughout the relevant period, has been its chief executive officer. Throughout the relevant period, he has wholly controlled all operations of ONPASSIVE and had ultimate authority over its activities, including the violative conduct at issue here. ONPASSIVE aka GoFounders and OFounders, was established as a Florida LLC on November 19, 2018, before being converted to a Delaware LLC on September 23, 2021. ONPASSIVE has maintained an office in Orlando, Florida, since 2018. At no time did the company have a category of securities registered with the SEC. The names ONPASSIVE, GoFounders and DoFounders have been used interchangeably to describe the company that has purportedly been developing AI applications, and also to describe the company's MLM program. All acts and omissions of ONPASSIVE as alleged herein were done at Mufarehs' direction. Relief Defendant. Asmahan Mufareh, age 39, is a resident of Orlando, Florida. She is Mufarehs' spouse and the co-founder and co-owner of ONPASSIVE, and she has received securities fraud proceeds to which she has no legitimate claim. Terms. Founders. Defendants use the term founders to describe investors who registered on ONPASSIVE's non-public website back office prior to product launch, or pre-launch, for the opportunity to be placed in a pyramid structure prior to later investors. The defendants claimed that founders would be ultimately eligible to receive as a commission a portion of monthly subscription fees paid by those placed after them in the pyramid structure. ONPASSIVE has purportedly placed each founder in the pyramid pre-launch in the order in which they registered. Defendants distinguished between founders that paid the $97 pre-launch versus those that had not yet paid. The defendants referred to founders who had not yet paid as holding free positions. The defendants represented that they could remove any founder holding a free position at any time prior to product launch and indicated that they would eliminate all such free positions prior to product launch so that only paying founders would be eligible to maintain their positions in the pyramid and elect to be a reseller. The defendants ceased accepting founder registrations on June 22, 2022. Reseller. The defendants required that, in order to receive commissions, an investor, whether they be a founder who registers pre-launch or someone who invests post-launch, also had to sign up on ONPASSIVE's back office to be a reseller. An ebook posted to ONPASSIVE's back office from December 2021 into August 2022 stated that every founder would elect to become a reseller. According to defendants, once having made the election to be a reseller, the electing person was not required to do anything further. Rather, ONPASSIVE stated that it would create a website for each reseller and that upon product launch ONPASSIVE would then engage in a marketing campaign to attract other potential investors or users of the purported product through the reseller's website using AI. ONPASSIVE said it would treat each purported product purchase made through a reseller's website as a resale. A portion of the monthly subscription fees paid by customers routed to each reseller's website would then be paid as a commission to the reseller. These resale commissions would be in addition to the commissions paid out of monthly subscription fees paid to each founder by the founders beneath them in the pyramid. Leadership Council. The defendants used the term Leadership Council to refer to a group of highly productive and enthusiastic founders selected by Mufarehs to promote ONPASSIVE. Back office. The defendants used the term back office to refer to ONPASSIVE's non-public website accessible by the over 800,000 investors who had registered as founders, or who were otherwise granted access by Mufarehs. It is not a product for commercial sale, but rather a tool used by the defendants to, among other things, facilitate and track recruitment efforts. Shape ebook. The defendants used the term ebook to refer to a digital composition, of which there were successive iterations, reviewed and edited by Mufarehs and then posted to ONPASSIVE's back office with Mufarehs' authorization, and which contained information concerning ONPASSIVE's fraudulent scheme. Launch. The defendants used the term launch through at least June 22, 2022. To refer to the purported commercial rollout of the product, with all applications, initially approximately 30 increasing to over 50, comprising the ecosystem to be made commercially available simultaneously, coincident with the commencement of commission payments. Facts. This court has jurisdiction over this action pursuant to the Securities Act and the Exchange Act. The court has personal jurisdiction over defendants and venue is proper in the Middle District of Florida, pursuant to the Securities Act and the Exchange Act, because certain of the transactions, acts, practices, and courses of business constituting violations of the federal securities laws occurred within this district. Defendants offered and sold securities at issue in this district, and individuals who reside in this district are among those who invested by paying $97 to defendants to be founders. Furthermore, Defendant Mufarehs and Relief Defendant Asmahan Mufareh reside in this district, and ONPASSIVE's principal place of business is in this district. The investments offered, purchased, and sold as alleged herein were securities as defined under the Securities Act and the Exchange Act. In connection with the conduct alleged in this amended complaint, defendants, directly and indirectly, singly or in concert with others, have made use of the means or instrumentalities of interstate commerce, the means or instruments of transportation or communication in interstate commerce, the mails, and or the facilities of a national securities exchange, namely, through defendants' use of the Internet, including for email, the transmittal of live webinars and of the same webinars, and informational ebooks posted to ONPASSIVE's back office. Facts. The ONPASSIVE Pyramid Scheme. ONPASSIVE is a pyramid scheme. ONPASSIVE is a pyramid scheme. ONPASSIVE offers investors, in return for their payment of money, the right to promote and sell ONPASSIVE's purported product and to receive income not primarily for the sale of the product to ultimate users, but rather in return for recruiting other participant recruiters, investors. These investors in turn are likewise incentivized to recruit still other investors in an unending and unsustainable chain of recruitment. ONPASSIVE's incentivized recruitment structure has no method or procedures in place to ensure that a substantial portion of sales are to bona fide retail users of the product. To earn commissions, an ONPASSIVE investor must purchase product and commence paying monthly subscription fees, with those paying the $97 founder's fee assured a higher place in the pyramid structure, relative to those who do not, so as to maximize their passive income streams. According to Defendants, other than making payments and checking a box electing to be a reseller, no further action by an investor is required to receive a passive income stream. The purported income opportunity has driven recruitment rather than the utility of the product. This is evident from, among other things, Defendants' successful solicitation of over 800,000 investors worldwide to purchase over 1.12 million founders' positions over the course of 4 years, during which time Defendants never commercially launched a single product and devoted their communications chiefly to describing the income opportunity. Of these over 800,000 investors, more than 93,000, nearly 12%, purchased multiple founders' positions. Given that each investor could purchase all the product the investor desired through one position, the purchase by over 93,000 investors of multiple founders' positions confirms that receipt of passive income is a driver of investor interest. Meanwhile, details on the products under development remain scant. Most ONPASSIVE investors are bound to lose money. Defendants claimed in their ebook that investors could earn unlimited residual income for life, and other marketing materials even indicated that investors could receive over $2 million per month for life. However, such claims depended on the unrealistic assumptions of infinite numbers of participants in the ONPASSIVE pyramid scheme. For example, to fully populate 10 more levels of the pyramid beyond the 10 levels depicted in paragraph 60 below would require 5.2 billion positions, assuming the number of positions in each successive tier increases by a factor of 3. It is not possible to have an infinite team of participants from whom an investor could earn unlimited residual income for life, as claimed in the ebook referenced in paragraph 62 below. The ONPASSIVE pyramid scheme relies on rewards unrelated to the sale of a product to ultimate users. In July 2018, Mufarehs, and ONPASSIVE, following its formation in November 2018, began soliciting investors to invest in ONPASSIVE's unlawful pyramid scheme by claiming that founders would share in profits that would purportedly come from monthly subscription fees paid by users to use a suite of online computer applications using AI. ONPASSIVE has yet to fully develop and make commercially available a suite of online computer applications. Defendants solicited investors, using email and live webinars, usually produced from Mufarehs' Orlando home, which were recorded and then posted to ONPASSIVE's back office for later viewing. ONPASSIVE's back office contained informational ebooks which Mufarehs reviewed, edited, and authorized to have posted. Anyone registering as a founder or granted access by Mufarehs could access ONPASSIVE's back office. Founders who actively promoted ONPASSIVE, particularly those comprising ONPASSIVE's so-called Leadership Council, also disseminated promotional materials on the public internet as part of their recruitment efforts, which Mufarehs and ONPASSIVE incentivized them to do by representing that each founder recruited by an existing founder would be placed under the existing founder in the pyramid. ONPASSIVE's promotional materials falsely conveyed that monies raised would be used for product development. The purported product would be a suite of computer applications using AI to automate marketing functions for online businesses. In February 2020, Mufarehs announced in a webinar posted to ONPASSIVE's back office that the target audience was being expanded to include anyone interested in using AI applications. Between August 2019 and at least December 2021, the number of computer applications the defendants claimed they would launch increased from approximately 30 to over 50. During the relevant period, defendants publicly stated that they would employ a software-as-a-service model where, rather than owning the products outright, customers would purchase a product package and then pay a monthly subscription fee to use the products. Investors could purchase placement in ONPASSIVE's unlawful pyramid scheme either by paying $97 in advance of the product launch or by waiting to purchase a software product on or after product launch. Under either option, defendants indicated that each investor would be placed in the pyramid in the order in which each registered. Defendants assured founders that, as they were early investors, the founders would be placed more highly than those registering on or after product launch. Investors would maintain their respective positions at or after product launch provided they made all required payments. An ebook that Mufarehs reviewed, edited, and authorized for posting to ONPASSIVE's back office in April 2019, declared, "When you accept an early founder position, you're placed in ONPASSIVE's top leadership. This is the top 1% of the leaders in the company, and the teams under these leaders are built literally hands-free. This is done through company-wide marketing campaigns using 4 or 5 of the world's best/largest data exchange companies to run the campaigns. These campaigns are fed using proprietary databases, developed and owned by ONPASSIVE, that consist of leads incredibly targeted to specific industries. Before the public launch, the primary purpose of the existing founders and the company campaigns are to invite other founders. The founders' positions are ranked according to 1. The date the position was acquired, and 2. The number of paid founders they have personally sponsored. A visual depiction often used in promotional materials posted to ONPASSIVE's back office and the public internet during the relevant period, advertised the pyramid incentive structure as follows. Defendants generally indicated that the pyramid under each recruit would be limited to 10 rows, with the number of positions in each successive row increasing by a multiple of 3, for a maximum of 88,523 positions all told, although defendants also occasionally indicated that the number of rows could be unlimited. Defendants further represented that the spillover concept applied, meaning that an investor who actively recruits others into the scheme could fill in vacant pyramid positions anywhere below the active investor in the pyramid to include positions below investors who were not actively recruiting. According to defendants' promotional materials and communications with founders, to maintain one's position in ONPASSIVE's pyramid at the time of purported product launch, a founder must have paid a $97 founder's fee, purchased a product package, and paid a monthly subscription fee in order to continue to receive commissions. The monthly subscription fee was initially specified as $25 to $900, depending on the product package the participant purchased. Investors were told in a video posted in the spring of 2019 to the back office that the $97 founder's fee would cover the first year of post-launch monthly subscription fees in their entirety. Those who were not founders would need to purchase product packages after launch to be placed in the pyramid and pay a monthly subscription fee to maintain a position in the pyramid and receive commissions. From inception, defendants claimed that ONPASSIVE would begin paying commissions upon product launch, when it began collecting monthly subscription fees. Defendants permitted investors to register as founders pre-launch while deferring payment to a later date, provided payment was made prior to product launch. Failure to pay the founder's fee in advance of launch would result in forfeiture of the so-called free position in the ONPASSIVE pyramid. By December 2021, defendants had modified the pyramid scheme participation requirements in 3 respects. First, the monthly subscription fees would no longer be in the range of $25 to $900, but substantially higher although unspecified amounts. Second, a founder's $97 initial payment would no longer be deemed to cover the monthly subscription fees due during the first year following product launch. Founders would now have to pay a monthly subscription fee. Finally, in addition to purchasing a product and commencing payment of monthly subscription fees at the time of a purported product launch, in order to receive commissions, an investor, whether a founder or an individual joining post-launch, would also now have to elect to be a reseller. Electing to be a reseller meant simply checking a box on ONPASSIVE's website. The election could be made at any time at or after product purchase, although ONPASSIVE's ebook posted to the back office from December 2021 into August 2022 asserted that every founder would elect to be a reseller. There was no added cost for electing to be a reseller, and electing to be a reseller did not obligate the electing person to do anything. At no time up through June 22, 2022, was a limit placed on the number of founder positions that an investor could purchase. Since a single founder's position would enable an investor to purchase product, the only reason for purchasing more than one founder's position was to secure multiple passive income streams. Although ONPASSIVE claimed that it ceased accepting founder registrations effective June 22, 2022, defendants continued to accept $97 payments from those founders holding free positions as of that date, resulting in the payment of tens of millions of dollars in founders' fees subsequent to June 22, 2022. Defendants promoted their pyramid scheme by emphasizing the passive income opportunity through recruitment. Throughout the relevant period, Defendants made clear how much an investor would receive in commissions was directly tied to how high in the ONPASSIVE pyramid an investor was placed relative to others, which, in turn, was a function of how many participants were recruited under them and in succeeding levels of the pyramid. Only a founder could recruit other founders, who would then be placed under and be sources of commissions for the recruiting founder. The defendants represented that on product launch, ONPASSIVE would engage in an intensive marketing program to attract new customers and, using an automated system, direct traffic to websites that they would create for each reseller, a founder or investor who joins post-launch. Individuals directed to a reseller's website who then purchased a product would be deemed a recruit of the reseller. ONPASSIVE tracked founders recruited by other founders and undertook to track recruits post-launch. Accordingly, defendants made recruitment of more founders and or resellers a focal point of their pyramid scheme from inception. Defendants also urged and incentivized investors to join as early as possible by emphasizing that the earlier interested parties joined, the more highly placed they would be in the pyramid relative to later joining participants, and the more they could earn in passive income from those placed under them. Although defendants emphasized that participants could maximize their passive income by recruiting others, defendants also told investors, whether founders or those considering joining later, that they could earn passive income without engaging in any recruiting activity, but instead relying entirely on ONPASSIVE to conduct marketing efforts and, post-launch, to place recruits ONPASSIVE solicited directly under existing participants in the pyramid structure. While defendants initially represented that they would release the suite of applications for business owners looking to create an online presence to market their services or products, they also repeatedly represented that investors did not need to have an already existing business. Rather, investors could use the purported product post-launch to market the ONPASSIVE program, and, implicitly, the passive income-making opportunity, thereby populating the pyramid under them with new recruits to maximize their own passive income stream. Thus, no business use for the product was needed beyond recruiting for ONPASSIVE, and the investors' profits would come from the recruitment of others into the scheme rather than from product sales to bona fide retail purchasers. The most heavily marketed aspect of the fraudulent scheme to attract investors was not the potential or value of the purported software application product, but rather the potential size of the income opportunity, about which defendants have made multiple and repeated materially misleading claims. For example, defendants falsely advertised in promotional materials and live and recorded webinars posted to the back office outlandish potential passive or residual returns to investors that could last for life. The payment grid below, which appeared in ONPASSIVE ebooks and webinars posted to ONPASSIVE's back office at least up through late 2020, purports to show how a participant could receive up to $2,032,614 per month for life. This number is based on the unrealistic assumption that 10 levels of recruits, comprising 88,573 commission-generating positions of persons buying in at varying levels, would populate the pyramid under the participant. Illustrative of how defendants used this payment grid is a webinar the defendants broadcast on September 25, 2018, and then posted to the company's back-office website. In the webinar, Mufarehs stated that the grid showed how it was possible for participants to receive over $2 million per month if up to 10 tiers under them were fully populated, and suggested that $30 million per month was feasible if more than 10 rows were populated. An ebook reviewed and edited by Mufarehs and posted to ONPASSIVE's back office with Mufarehs' authorization from December 2021 to August 2022 claimed that a participant could have an infinite team of downstream recruits from which the participant would draw commissions and earn unlimited residual income for life. Elsewhere, the same ebook stated that a participant could earn thousands and even millions of dollars. Additionally, in February 2020, Mufarehs reviewed and approved for posting in the back office a false marketing message from a founder with realistic, conservative, and worst-case scenarios that projected founders would earn over $32 million with the system, and which touted the purported income benefits of buying multiple positions. Throughout the relevant period, Mufarehs knew or was reckless in not knowing that the representations set forth in paragraphs 59 through 63 concerning the purported income that could be earned from investing in the ONPASSIVE pyramid scheme were factually unsupportable and materially misleading. As CEO, co-owner, and the ultimate authority over all ONPASSIVE operations and statements, Mufarehs' scienter is imputable to ONPASSIVE. A reasonable investor would have wanted to know that ONPASSIVE was a pyramid scheme. A reasonable investor would have wanted to know that ONPASSIVE was unsustainable and could never deliver on the passive or residual income Mufarehs and ONPASSIVE promoted to investors. Throughout the relevant period, Mufarehs has known or been reckless in not knowing that ONPASSIVE is a pyramid scheme that has operated and continues to operate as a fraud or deceit on investors. Mufarehs' scienter is imputable to ONPASSIVE. Defendants made material misrepresentations in furtherance of the pyramid scheme. In addition to those material misrepresentations addressed above, and in furtherance of their pyramid scheme, defendants made other materially false and misleading statements or omitted information which made those statements which were made materially misleading. Defendants fraudulently misrepresented that ONPASSIVE was legal and fully compliant. During the relevant period, defendants misrepresented to investors that ONPASSIVE was engaged in a legal business when they knew or were reckless in not knowing that they were operating an unlawful pyramid scheme. During the relevant period, defendants misrepresented to investors that ONPASSIVE was engaged in a legal business when they knew or were reckless in not knowing that they were operating an unlawful pyramid scheme. Defendants' misstatements that ONPASSIVE was engaged in a legal business were made in webinars dated September 25, 2018, July 18, 2019, and June 11, 2020, which were posted to the back office. In a webinar dated August 29, 2019, Mufarehs falsely declared that ONPASSIVE was legal in every country in which it operated, or there would be workarounds to make it legal. Ebooks, which Mufarehs reviewed, edited, and authorized for posting to ONPASSIVE's back office in April 2019 and again in December 2021, stated, "We are fully legal worldwide, we are fully compliant worldwide, and we will not be shut down by a government, they will use our products." The foregoing misrepresentations were material because a reasonable investor would want to know if an investment opportunity was illegal in deciding whether to invest. Mufarehs' entire course of dealings, as alleged in this amended complaint, reflect his awareness that ONPASSIVE is an illegal pyramid scheme. His scienter is imputable to ONPASSIVE. Defendants fraudulently misrepresented the feasibility and timing of product launch. Mufarehs, beginning in July 2018, and ONPASSIVE, following its formation in November 2018, made material misstatements up through at least October 2020 regarding the feasibility and timing of the product launch, while knowing or being reckless in not knowing that they lacked a factual basis for making the statements. Beginning on July 17, 2018 and continuing through at least October 2018, Mufarehs composed and sent, or directed others to send, hundreds of emails to potential investors containing the text, "I, Mufarehs, will send an update when the program launches in about 1 month." On September 25, 2018, Mufarehs said in a live webinar, a recording of which was posted to ONPASSIVE's back office, "We're closer to launch, we're in the second half, maybe the last third, and you do the math. I don't have a date, I'm going to touch up on that respectfully. Is it realistic to launch in the next 30 days? Very much possible, I would say okay." On October 3, 2018, Mufarehs said in a live webinar, a recording of which was posted to ONPASSIVE's back office, "We are definitely closer to the launch than when we announced this concept, let's say in the past, so we're clearly in the probably last third or quarter maybe." In a webinar dated April 25, 2019, a recording of which was posted to ONPASSIVE's back office, Mufarehs represented that ONPASSIVE would be launched or nearly ready to launch by the end of June 2019, then 2 months away, saying, "In June we will have a kickstart party in Orlando. Last weekend of June. Celebrate launch or opening, whether it's already open or getting tested, just ready to launch." In a webinar dated March 26, 2020 and posted to ONPASSIVE's back office, Mufarehs stated that ONPASSIVE is going to launch, it is everything looking good for 2020. On August 6, 2020, Mufarehs stated in a webinar, a recording of which was posted on ONPASSIVE's back office, that ONPASSIVE is scheduled and set to launch in 2020. If we need more time we will let you know right now. We don't feel there's any unnecessary time to launch. We have plenty of time for the remaining portion of unfinished part of ONPASSIVE to complete it in 2020. Mufarehs thereafter reviewed 6 emails drafted by members of ONPASSIVE's Leadership Council which reiterated Mufarehs' August 6, 2020, pronouncement that there would be a 2020 launch date, and which were transmitted via ONPASSIVE's official email address to prospective and existing investors on various dates from August 31 through October 31, 2020. In a webinar dated October 15, 2020 and posted to ONPASSIVE's back office, Mufarehs stated that all that was left was realistically a few weeks of testing, saying, "If now we are considered in pre-launch, how much more launch you want, like okay just that ribbon cutting? It will happen. It's a done deal in my mind, that's why I operate as we already have a multi-billion-dollar business in every country on the planet." Each of the foregoing statements was false when made because, first, defendants did not have the personnel to develop the applications along the timelines indicated above, and, second, to the extent defendants hired personnel and expended resources, at least up through August 2020, it was chiefly to develop ONPASSIVE's back-office website used for recruiting new investors, tracking placement in the pyramid structure, and marketing the ONPASSIVE income opportunity. For example, in July 2018, when Mufarehs started making, directly or indirectly, the first of the statements referenced above that the program would launch in about 1 month, Mufarehs and Asmahan Mufarehs were the only two persons involved with any aspect of ONPASSIVE's operations, and neither had any expertise to develop a suite of computer applications using AI. While Defendants retained an information technology (IT) outsourcing firm in September 2018 and subsequently brought IT personnel in-house, at Defendants' direction the IT firm and in-house personnel focused their efforts, at least during the first 2 years, on developing ONPASSIVE's back office for purposes of recruiting investors rather than the software applications ONPASSIVE was purportedly launching. As mentioned, as of August 2020, the same month that Defendants announced that the product suite would include 30 software applications that would work together in an ecosystem, Defendants had completed only 2 comparatively simple software applications, an Internet Protocol Address (IP) tracker and a Uniform Resource Locator (URL) shortener, equivalents of which were already readily available to the public online for free. Defendants had not launched the 2 software applications, by which Defendants had stated they meant the commercial launch of the ecosystem comprised of all applications simultaneously. Moreover, development of most of the 30 applications that were to comprise the ecosystem had not even commenced by August 2020. Defendants' statements about ONPASSIVE's purported product launch were designed to lull investors into believing that a real product launch would occur when in fact no such launch occurred, and no commissions were paid to founders as promised. In November 2022, Defendants made available to the general public 4 applications, including the IP tracker and URL shortener, all free of charge. Defendants have since offered 2 additional applications available to the general public free of charge. As of June 30, 2023, the remaining 44 applications had yet to be released and the product launch, defined as the commercial offering of product, which is supposed to prompt the payment of monthly subscription fees generating commissions, had yet to occur. Defendants' misrepresentations were material to investors' decisions whether to invest because only after the product launch could investors expect their first returns in the form of commissions. The misrepresentations that a product launch would likely occur within specified short timeframes would also have spurred founders who held free positions to pay their $97 fees before the window closed. At the time he made each of the statements set forth in paragraph 73 above, Mufarehs knew or was reckless in not knowing that the statements were materially false and misleading. Specifically, he knew or was reckless in not knowing at the time of each statement that development of applications had not yet started, let alone progressed to the point that product launch could occur within the timeframes specified, and that ONPASSIVE lacked the capacity to develop the applications in the timeframes specified. Mufarehs' scienter is imputable to ONPASSIVE. Defendants created counterfeit and misleading websites on which to post fake independent third-party positive reviews in furtherance of their pyramid scheme. In early 2019, pre-existing and independently operated third-party MLM review blog websites, Review Site 1 and Review Site 2, posted multiple negative reviews of the defendants. Illustrative of the negative reviews were the following. On January 7, 2019, Review Site 1 posted that, "There's inherently nothing of particular interest with ONPASSIVE. It's literally nothing more than a pyramid scheme launched by a serial scammer." On or before February 28, 2019, Review Site 2 posted that, "ONPASSIVE is a scam, and here is our main reason why: no retail products offered. Sure, the company offers a marketing platform that you can gain access to, but only as an MLM affiliate member." The defendants initially responded to the negative reviews by telling participants to ignore the haters. When the negative reviews persisted, however, Mufarehs approved in November 2019 the creation of counterfeit and intentionally misleading websites mimicking the names and appearances of the above-mentioned existing websites and the writing and posting on the counterfeit websites of positive reviews of ONPASSIVE and Mufarehs. ONPASSIVE personnel specifically proposed to Mufarehs and he agreed to the proposal that they would use these 2 counterfeit sites as third-party site, write, exclusive reviews on our own brand, just like a third person's writing, and use both counterfeit websites to influence the people, with the first target assigned being to knock down those review sites from the search results. The names of the 2 counterfeit sites purposely tracked the names of existing MLM review websites in their web URL addresses with slightly altered domain names, the domain extension .us of the counterfeit review site 1 site differed from the domain extension .com of the existing review site 1, and the domain name of the counterfeit review site 2 differed from that of the existing review site 2 only in the substitution of the singular for the plural of review site 2's name. Logos appearing at the top of each page of the counterfeit websites included the text of review site 1's and review site 2's names. In November 2019, Mufarehs personally registered the 2 counterfeit websites, paying to have the sites registered under the name of a domain proxy to conceal his and ONPASSIVE's involvement with the website sites. By concealing their involvement, Mufarehs and ONPASSIVE sought to deceive investors into thinking that the reviews posted on the counterfeit sites were objectively made by independent third parties. As directed by Mufarehs, to whom they reported regularly on their progress, ONPASSIVE personnel set about operating the website starting in late 2019 in a manner to mislead visitors as to the site's objectivity. For example, in the counterfeit review site 1 About section, ONPASSIVE personnel wrote, "Our only objective is to educate users who are searching for companies, including MLM, primary target industry. We summarize a company's overall status and reputation in the market. These reviews could help any user to identify and decide whether to approach a company or not to for any business or professional reasons." Further, ONPASSIVE personnel not only posted reviews of Mufarehs and ONPASSIVE, which were uniformly favorable, but also posted reviews of other programs and advice on MLMs generally, which tracked third-party MLM review sites, so as to further the deception. As authorized by Mufarehs, ONPASSIVE personnel wrote and posted 7 positive reviews of Mufarehs and ONPASSIVE on the counterfeit review site 2 website between November 2019 and March 2020, 7 of which remained online until at least November 2021, and 6 of which remained online until at least October 2022. One such review, posted on November 30, 2019, stated, "Do we recommend you to join ONPASSIVE? The answer is, yes, we do recommend you to be part of ONPASSIVE. And it's a scam-free, fully legit and compliant and has a global presence in more than 100+ countries." As authorized by Mufarehs, ONPASSIVE personnel wrote and posted 6 positive reviews of Mufarehs and ONPASSIVE on the counterfeit review site 2 between December 2019 and March 2020, which remained posted online until at least October 2022. One such review, posted on February 16, 2020, stated, "Why do I believe that ONPASSIVE is responsible for taking my business goals to heights, which I never thought I could? With all of these advantages in front of my eyes, I couldn't stay blind and not plunge into becoming a member of ONPASSIVE." The creation of the counterfeit websites and posting of fake positive reviews of Mufarehs and ONPASSIVE acted as a deceit on investors by falsely purporting to be objective third-party sites and data. In addition, in omitting to disclose that the sites and reviews were controlled by ONPASSIVE and its personnel, the statements made were materially misleading. Mufarehs authorized and participated in the creation of the counterfeit websites and authorized the posting of the internally generated positive reviews of himself and ONPASSIVE. Mufarehs understood the impact on investors of positive reviews posted to MLM websites, observing in a June 11, 2020, webinar posted to the back office, for example, that someone who spots a positive review online was more likely to register for ONPASSIVE and pay the $97 fee to become a founder. A reasonable investor would have wanted to know that the websites were counterfeit, that they were owned and controlled by Mufarehs and ONPASSIVE, and that the positive reviews were not independent but instead written by ONPASSIVE personnel and approved by Mufarehs. Mufarehs knew or was reckless in not knowing that the creation of the counterfeit websites and posting of fake positive reviews of Mufarehs and ONPASSIVE was a device, scheme or artifice to defraud and operated or would operate as a fraud or deceit on investors because purporting to be objective third-party sites and reviews, and that, in omitting to disclose that the sites were created and operated by ONPASSIVE and that the postings were internally generated by ONPASSIVE personnel, those statements that were made were materially misleading as a result because falsely conveying that they were the product of objective third parties. Further, Mufarehs knew or was reckless in not knowing that the operation of the pyramid scheme, the creation of the counterfeit websites, and the material misrepresentations and omissions collectively constituted a scheme to defraud and operated or would operate as a fraud or deceit on investors. Mufarehs' scienter is imputable to ONPASSIVE. Defendants engaged in the unregistered offer and sale of securities. Federal securities laws require that those offering or selling securities disclose certain information by filing a registration statement with the SEC. This information allows investors to make informed judgments about whether to purchase the securities. Mufarehs and ONPASSIVE offered and sold opportunities to invest in a pyramid scheme to the general public, including investors throughout the United States, and raised at least $108 million in investor proceeds. Mufarehs and ONPASSIVE pooled these investor funds to operate the business to include developing and marketing the purported ecosystem of software applications and make the pyramid opportunity profitable. Accordingly, investors' expectations of profit were, and still are, dependent on Mufarehs and ONPASSIVE's ability and supposed efforts to develop the purported product and make the pyramid opportunity a profitable endeavor. The offer and sale of the opportunity to participate in ONPASSIVE, which is a pyramid scheme, constituted an investment contract and, therefore, a security. The offer and sale of the opportunity to participate in the ONPASSIVE pyramid scheme was not registered with the SEC. No exemption from registration applied. Defendants and relief defendant Asmahan Mufarehs received investors' funds. As a result of the foregoing, defendants had raised in excess of $108 million in illicit proceeds from investors as of March 2023. Ill-gotten gains were received by defendants from investors through a variety of different methods, including in crypto assets, cash, check, wire transfers, and various third-party payment services. All of these payments went into accounts which were and/or are subject to Mufarehs and/or Asmahan Mufarehs' control. Mufarehs and/or Asmahan Mufarehs have converted a sizable quantity of investors' payments into crypto assets, while holding other proceeds in accounts with financial institutions. From these proceeds, Mufarehs and Asmahan Mufarehs have expended substantial sums on personal expenses, including fine dining, luxury resort stays, car rentals, day spas, hair salons, martial arts lessons, and jewelry purchases. Asmahan Mufarehs has received ill-gotten funds, and does not have a legitimate claim to those funds. First claim for relief. Unregistered offers and sales of securities, against defendants Ashraf Mufarehs and ONPASSIVE. Paragraphs 1, 10, 21-22, and 91-95 are realleged and incorporated by reference as though fully set forth herein. Investors in defendants' pyramid-structured sales program made investments of money in a common enterprise about which they were led to expect profits from the efforts of defendants or third parties. Investor subscriptions in the defendants' pyramid-structured sales program constituted investment contracts, which are securities. By engaging in the conduct described above, defendants, singly and in concert with others, made use of the means or instruments of transportation or communication in interstate commerce, or of the mails, to offer to sell or to sell securities, or carried or caused to be carried through the mails or in interstate commerce, by means or instruments of transportation, securities for the purpose of sale or for delivery after sale, when no registration statement had been filed or was in effect as to such securities, and when no exemption from registration was applicable. By engaging in the conduct described above, defendants directly or indirectly violated, and unless enjoined are reasonably likely to continue to violate, Securities Act Sections 5A and 5C. Second claim for relief. Fraud in violation of Securities Act, against defendants Ashraf Mufarehs and ONPASSIVE. Paragraphs 1-17, 21-22, 24-29 and 33-99 are realleged and incorporated by reference as though fully set forth herein. By engaging in the conduct described above, defendants, in the offer or sale of any securities by the use of the means or instruments of transportation or communication in interstate commerce or by use of the mails, directly or indirectly, knowingly or recklessly employed a device, scheme, or artifice to defraud as alleged. Negligently obtained money or property by means of an untrue statement of a material fact or an omission to state a material fact necessary in order to make the statements made, in light of the circumstances under which they were made, not misleading as alleged, and negligently engaged in a transaction, practice, or course of business which operated or would operate as a fraud or deceit upon the purchaser as alleged. By reason of the foregoing, defendants violated, and, unless enjoined, are reasonably likely to continue to violate, Section 17A, 1A, 3, of the Securities Act. Third claim for relief. Fraud in connection with the purchase or sale of securities in violation of Exchange Act, against defendants Ashraf Mufarehs and ONPASSIVE. Paragraphs 1-17, 21-22, 24-29 and 33-99 are realleged and incorporated by reference as though fully set forth herein. By engaging in the conduct described above, defendants directly or indirectly, by use of the means or instrumentalities of interstate commerce, or of the mails knowingly or recklessly, Employed a device, scheme, or artifice to defraud as alleged. Made an untrue statement of a material fact or omitted to state a material fact necessary in order to make the statements made, in the light of the circumstances under which they were made, not misleading as alleged, and engaged in an act, practice, or course of business which operates or would operate as a fraud or deceit upon any person as alleged. By engaging in the foregoing misconduct, defendants violated, and unless enjoined are reasonably likely to continue to violate, Exchange Act Section 10(b) and Rule 10b-5(a), copyright thereunder. Fourth claim for relief. Violation, as a control person, of Exchange Act, against defendants Ashraf Mufarehs and ONPASSIVE. Paragraphs 1 to 17, 19, 21 to 22, 24 to 29 and 33 to 99 are re-alleged and incorporated by reference as though fully set forth herein. As alleged in paragraphs 1 to 17, 24 to 29 and 33 to 99, ONPASSIVE violated Exchange Act Section 10(b) and Rule 10b-5(a), c. At all relevant times, Mufarehs controlled ONPASSIVE and was a culpable participant in its violations of Exchange Act Section 10(b) and Rule 10b-5(a), c. By reason of the foregoing, Mufarehs is liable as a controlling person, pursuant to Exchange Act Section 20(a), for ONPASSIVE's violations of Exchange Act Section 10(b) and Rules 10b-5(a), c. thereunder. Fifth claim for relief. Unjust enrichment, against relief defendant Asmahan Mufarehs. Paragraphs 1 to 17, 21 to 23, 24 to 29 and 33 to 99 are re-alleged and incorporated by reference as though fully set forth herein. Exchange Act Section 21(d) 5, states, in any action or proceeding brought or instituted by the SEC under any provision of the securities laws, the SEC may seek, and any federal court may grant, any equitable relief that may be appropriate or necessary for the benefit of investors. As alleged, relief defendant Asmahan Mufarehs received investor funds and assets that were the proceeds, or are traceable to the proceeds, of defendants' unlawful activities, and relief defendant Asmahan Mufarehs has no legitimate claims to those proceeds and gave no consideration for exchange of those funds. Relief defendant Asmahan Mufarehs obtained the funds and assets as part of and in furtherance of the securities violations alleged, and under circumstances in which it is not just, equitable, or conscionable for them to retain the funds and assets. As a consequence, relief defendant Asmahan Mufarehs was unjustly enriched. Relief requested. Wherefore, the SEC respectfully requests the court find that defendants committed the violations charged and that, as a result of these violations, defendants and relief defendant Asmahan Mufarehs received ill-gotten gains, and enter final judgments. 1. Permanent injunction. 1. Permanent injunction, permanently restraining and enjoining defendants Mufarehs and ONPASSIVE, their officers, agents, servants, employees, attorneys, and all persons in active concert or participation with them, and each of them, from directly or indirectly violating the federal securities laws alleged in this amended complaint, and further permanently restraining and enjoining defendants, their officers, agents, servants, employees, attorneys, and all persons in active concert or participation with them, and each of them, from directly or indirectly offering, operating, or participating in any marketing or sales program in which a participant is compensated or promised compensation solely or primarily for inducing another person to become a participant in the program, or if such induced person induces another to become a participant in the program. 2. Disgorgement with prejudgment interest. 2. Disgorgement with prejudgment interest, ordering defendants and relief defendant Asmahan Mufarehs to disgorge all ill-gotten gains, with prejudgment interest, as a result of the acts or courses of conduct alleged in this amended complaint, with disgorgement from the defendants to be on a joint and several basis, pursuant to the Exchange Act. 3. Civil money penalties. 3. Civil money penalties, ordering defendants Mufarehs and ONPASSIVE to pay civil money penalties pursuant to the Securities Act. 4. Officer and Director Bar. 4. Officer and Director Bar, prohibiting defendant Mufarehs from acting as an officer or director of any issuer that has a class of securities registered pursuant to Section 12 of the Exchange Act or that is required to file reports pursuant to Section 15(d) of the Exchange Act, pursuant to Section 21(d)(2) of the Exchange Act and Section 20(e) of the Securities Act. 5. Further relief. 5. Further relief, granting such other and further relief as the court determines to be necessary and appropriate. 6. Retention of jurisdiction. 6. Retention of jurisdiction. Further, the SEC respectfully requests the court retain jurisdiction over this action and over defendants in order to implement and carry out the terms of all orders and decrees that may hereby be entered, or to entertain any suitable application or motion by the SEC for additional relief within the jurisdiction of this court. Demand for a jury trial. Demand for a jury trial, pursuant to Rules 38b and 39a of the Federal Rules of Civil Procedure. The SEC demands trial by jury on all issues so triable. Thank you for watching. Please like and subscribe as we will continue to bring updates as this case against ONPASSIVE, Ash Mufareh, and his wife, Asmahan Mufareh, progress through the courts.